My name is Tim Baldwin, and I'm chairing this seminar, and it's the seminar that is entitled Resumption of Possession Hearings and Execution of Warrants from the 21st of September 2020, and it's identified as new procedural rules and notice requirements. And for those who aren't familiar with these webinars, that you've all been placed on mute at the moment at the start of the seminar. And what will happen is that if you have any questions that arise during the seminar, I ask that you post the questions in the chat window that you'll be able to see as part of the control buttons at the bottom of your Zoom window. You will then, so that I can collate them, and what we can do towards the end of the seminar is pose those questions to the appropriate speaker at the end, towards the end of the webinar. It may not be that we answer all of the questions, or it may be that they get answered later on by an email or something like that. But if you do have questions, feel free to put them into the chat window. And the presentation slides will be circulated to those who are registered after the webinar. And just to warn you that, well, not warn you, but to tell you that the webinar is being recorded, and what this means is that the audio and video of the presenters and anyone who speaks, if they're unmuted, will be recorded, and the webinar will be shared by our marketing team to you at the end of the webinar once it's all collated. So the audio and video will be recorded and shared with you. So moving on to where we are today, we have two well-known speakers, that's Marina Sergides and Liz Davis, who really need very little introduction to anybody who is an active participant in housing law and housing practice. And what we're going to have is Marina is going to start out the seminar. She's going to speak for about 40 minutes, and then followed by Liz, who's going to speak for about 15 to 20 minutes. And just to add that we do have additional expertise from Marina, and that is that given her role as co-chair of HELPA, she and Simon Mullins have been actively involved in the working group with the Master the Roles, and that work has been really excellent and has enabled those who are to run the courts to get some really strong insight from practitioners and what to expect. If you do have technical problems during the webinar, I Marina, and Liz cannot really help you, but if you place that within the chat box, we can try and sort that out for you if we can do. And there's a note that Amy, our marketing assistant, has put into the chat box to that effect. So I'm not going to say very much during this seminar. As you can see, I've been long put out to grass from my background. So what we're going to do is we're going to start the webinar with Marina, who's going to start her slides. And I'm going to mute myself now, and Marina can unmute herself to start the webinar.
Great. Thanks, Tim. I hope you can all hear me. If there's any problems, as Tim said, please let Amy know. Thank you for joining this morning. There's quite a few of you. I can't see your faces because I've got my screen up, but it's good to have you here. This is all very new, which is probably why you're all here, of course. Although I've been on the working group, as Tim says, it's still new to me. I'm still learning as I go along, and although I will try and set out in the best way that I can what the new procedure will look like, or process will look like, I should say, it may be that I'm not actually able to answer all of your questions simply because it's so new and we don't really know how it's all going to work out in practice. But anyway, I will certainly try my best to set it all out in the best way that I can. So as you can see from the first slide, it's been a long road. Possession proceedings have been stayed now on 3 separate occasions, but they are now going to come back into force on the 21st of September. The working group appointed by Master of the Rolls was set up to discuss what the procedures were going to be after the 21st of September, with the aim, as I set out in the slide, of primarily reducing the volume of possession proceedings in the system. And that was going to happen by doing 2 things, by ensuring that tenants would receive early legal advice and by increasing the opportunity for settlement. There is a real concern that there's going to be an increase in possession proceedings, not only in respect of those proceedings that were stayed, of which there are many, but those possession cases that would have arisen over the period of the pandemic, and of course those possession proceedings that are likely to arise in the coming months. So there are a huge number of cases going through the system, and the primary aim is to reduce the pressure on the courts. I have put there that court closures have no doubt had their impact. That wasn't necessarily a relevant consideration for the working group, but I think we are all in our own practices and our experience of the courts over the last 10 years well aware of the impact that that's going to have. So what are the overall arrangements and how is it going to work? Well, the first thing I should say, and it's probably the most important thing, is that there are no changes to the civil procedure rules other than the introduction of Practice Direction 55C and some changes to the warrant stage, which I'll come on to. But in terms of the possession proceedings, there are no other substantive changes to CPR 55. Okay, that's it. What you have in the Practice Direction is it. There are changes to the notice periods that Liz is going to talk about, but they are in respect of the primary legislation. There are changes to the overall arrangements and the process that the courts are going to adopt, but they are going to be dealt with almost entirely as listing matters. They are not going to be dealt with as a response to changes in the actual rules other than what's in the Practice Direction. So CPR Part 3 will be doing a lot of the heavy lifting. The court office will be doing a lot of the heavy lifting, and this will be a listing matter which will vary across the different courts in England. Okay, so the practice and procedures that are eventually adopted, perhaps in Clerkenwell, for example, may not be the procedures and practices that are adopted in other courts, and I think that's important to bear in mind from the outset. Okay, and I also think that that's probably done intentionally to allow different courts to deal with the different pressures that are on them. Moving on. There has been, and I should say there's also been no, and I think we all know at the moment, no changes, no indication there's going to be any change to the primary legislation in respect of Ground 8 or Section 21. Okay, so this is all being done within the primary legislation as we know it. There has been some increased funding from the Ministry of Justice and from the Ministry of Housing. That increased funding is, however, directed towards facilitating negotiation, which I'm going to come on to further, which is an entirely new concept in housing, not something that we as practitioners are used to, but again, I'll deal with that in due course. There's also going to be some changes to the housing duty contract, or some variations to allow duty advice at 2 stages now, which again, I'll come on to. That's at what we will call the review date and at the substantive hearing. So how's it all going to work? Well, before I talk about what's on your screen at the moment, stayed claims and reactivation notice, I just want to give you an overall picture of how it will look. At At the moment, we're all used to cases where a claim for possession is put in, and in response to that claim for possession, we have what we have historically known as first hearings and block lists. It's not unusual for hearings to be listed at about 60, possibly even more cases at any one time, listed for approximately 5 minutes. Some tenants don't turn up, some tenants do, some landlords don't turn up, some landlords do, and the court has to manage that very heavy list. They rely in doing that on duty advisors who may see possibly up to 10 people a day or any block list. That will go. There will be no block lists. The courts will not be listing 60 cases for 5 minutes. The courts will be listing first hearings at 15-minute intervals, and there will be a duty advisor. But they will be listed at 15-minute intervals to allow for safety precautions between hearings. Before we get to what we have all been used to as being the sort of first hearings, before that, there is going to be a whole other process in place. And that process will be managed by listing, in essence. And that is to list 21 days after a reactivation notice, which I'll come and explain now, a review date. And I'll come on to explain review dates and substantive hearings in a moment. But I just want to give you all a general picture as to how it's going to work. The review dates will be listed 21 days after the reactivation notice, and they are not hearings, they are dates, all right? As I say, I'll explain precisely what that means in a moment, but there will be the opportunity for duty advice at that stage. 28 days after the review date, the matter, if it's not resolved, will be listed for what is called a substantive hearing, what we are all used to as the current first hearings. So the requirement to list the first hearing within 8 weeks of the claim form has now gone. That's in the practice direction. And there will be a review date followed by a substantive hearing. Block lists will go and substantive hearings will be listed for 15 minutes. Okay. How we get to that will depend on the type of case that it is. And that's what I'm going to come on to and explain now. All right. So let's go back to reactivation notice. So reactivation notice, the term that we're all familiar with, I hope by now, and that's in Practice Direction 55C. Up until yesterday, there was no, the government had yet to publish what was going to be what a reactivation notice looked like. They were published yesterday, they are on the government website, and hopefully you will be able to link to that as I provided the link in the notes themselves. But the reactivation notice are only relevant in circumstances where the stayed claim was issued before the 3rd of August 2020. Sorry, there's a typo in my paper. I put 202, which is not a year at all, in 2020. So if the case was issued before 3rd of August 2020, the landlord or the tenant can issue a reactivation notice. Okay, that reactivation notice has to be issued in all cases except where, as I say, the case was brought after 3rd of August 2020 or there has been a final order for possession. I have to say the practice direction and the overall arrangements, which I'll come on to in a moment, do not define what is meant by a final possession order. Okay, I have taken it to mean a possession order that is not subject to an appeal. Although that's not written anywhere or explained anywhere, that is my own interpretation. But that's the requirement. The reactivation notice itself requires a number of factors to be mentioned or information to be given to the court. The first is that the party filing and serving wishes the case to be listed, relisted or heard. The second is that the party filing, issuing and serving the reactivation notice must provide any information as to the effect of coronavirus or the coronavirus pandemic on the tenant or their dependents. The third is that unless the proceedings relate to an appeal, and if the claim relates to rent arrears, the reactivation notice must provide an up-to-date rent account for 2 previous years. And the fourth is that where there were previous directions, the party must also file a copy of the last directions, any possible new dates for compliance and any new directions required. Okay. Now, the reason that information in respect of coronavirus is requested is because, as we'll come on to in a moment, what the court what these new procedures processes are concerned about is that information in respect of coronavirus reaches the court, and we'll come on to why that's important in a moment. But it is a central feature of the reactivation notice requirements. And if you look at the reactivation notice itself, there's a big box that asks the parties to complete that. Okay. If the directions are not agreed, the defendant, who will have notice of the reactivation notice, because of course it must be served on the other party, should notify the court that those directions are not agreed and must do so within 14 days. So where directions are not agreed between the parties, one would hope that a hearing is not listed until after the 14 days have passed. Okay, so the court is fully aware of whether or not the directions are agreed or not. Moving on, the reactivation notice is a trigger to list the R date, okay, the review date, 21 days after. Okay. Now, the wording of the practice direction, as set out in paragraph 3.1 of the practice direction, is that the court, unless it directs otherwise, must give at least 21 days notice to the parties of any hearing in response to the reactivation notice. Now, the practice direction that you have all had and no doubt read does not define what a hearing is. It does not tell the parties what hearing will be listed after 21 days. Ordinarily, under the old rules, we would all expect a hearing to mean a first possession hearing, as it was in the block list, listed for 5 minutes. That's what our expectation was. That has changed. When one looks at practice direction 55 together with the overall arrangements, and I should say, and I didn't say this, it has been issued by the Master of the Rolls and was published yesterday, has been tweeted out by Garden Court this morning, and no doubt you will read at some point. But what the overall arrangements do is to expand and set out all the things that I'm now talking about. So just going back, when one looks at the hearing that is to be listed 21 days after the reactivation notice, the practice direction doesn't tell us what that hearing is. The overall arrangements that are not CPR, okay, and don't have the full force of the law, if you like, the overall arrangements do give us some further clarification as to what a hearing may be. The relevant parts of the overall arrangements, when of course you have the opportunity to read them, because I appreciate they were only published yesterday and most of us only tweeted them out this morning, are set out in paragraphs 36, 37, 38. Now, the starting point is that the hearing that is listed after 21 days will be the review date, okay? It's not a hearing, it's a review date. It's not a trial, it's just a date, okay? That's what we expect will happen. That's the fallback position. Okay. If parties agree to something different, then the hearing will be possibly what it is that the parties have agreed. Okay, and that's at paragraph 38 of the overall arrangements. However, things get a little bit more complicated in circumstances where parties perhaps don't agree on what those directions will be, and a dispute between the parties has arisen, and the court has to resolve that dispute. The point I make on this slide, and I don't want to get into too much detail about this, okay? But when you look at practice direction 55D, and you take the practice direction together with the overall arrangements, it is not always clear what the hearing 21 days after the reactivation notice will be. And this is where there will be a different approach amongst different courts, okay? Some courts will say, following the strict guidance in the overall arrangements, the first hearing will always be a review date, even though review date is not a hearing. Okay. Other courts may say, well, depending what stage the parties are at, we may list this for a direction hearing, or we may list this for something else. Okay. We may list this for a directions hearing to resolve the dispute between the parties as to what the direction should be. Some of you might be thinking, what's the problem? Why can't they all be listed for a review date so that issues can just be resolved regardless as to what they are? And I'll come on to why that's a problem in a moment, okay? But just for the moment, what is clear is that herein lies a potential conflict between what's in the practice direction 55C, and paragraphs 36 to 39 of the overall arrangements. So when you're going through both documents, I would simply ask you to take note of where we're at in respect of how we define and what is the hearing to be listed 21 days after the reactivation notice is served. Okay. Is a reactivation, these are some further potential issues, is a reactivation notice served after the 23rd of August 2020, bearing in mind we only got the reactivation notice yesterday, is the reactivation notice served at this point valid? Well, again, the answer isn't entirely clear to this. The overall arrangements that I had seen yesterday morning made a distinction between those reactivation notices that are lodged but not issued. The overall arrangements that I saw yesterday afternoon after lunch had deleted that wording and adopted a slightly different wording. Okay. I can tell you that I think my understanding is that reactivation notices that have been served or issued or lodged, I should say, before the 20th of September, 21st of September, are simply to stay on the court file and will not be acted on until Monday the 21st of September. Okay. The reason that's the case is because reactivation notices are a step taken in the proceedings, and of course we know that all proceedings are stayed, and we know that not only from the practice direction but also from the case of Arkin. So reactivation notices served before Monday the 21st of September will stay on the court file, and my understanding, again, although this may vary court to court, is that come Monday they will be acted upon by the court. Okay. There is a potential further issue in respect of the practice directions following the Court of Appeal case of Dawn Meat. I'm actually not going to discuss that in any detail now because I think that's getting in some of the practical difficulties, but I will urge you to read my notes on that, and if people do have questions they can put it in the chat box and I can try and answer them at the end of this talk. So what do landlords have to bring to the hearing? Well, again, we don't quite know what the hearing will be. There is a presumption, and the fallback position will always be that the hearing after 21 days will be the review date, even though it's not a hearing. But whatever that hearing is, the first hearing to be listed after the reactivation notice requires the landlord to do certain things. Okay? It requires the landlord to bring 2 copies of a notice, confirming they have complied with the pre-action protocol, and set out what knowledge they have of the coronavirus effect on the defendant. Okay? It requires the landlord to bring that to the first hearing to be listed after the reactivation notice, but it also requires the landlord to give the tenant copies of this information and these notices 14 days before the hearing. Okay. Now, it's not quite clear what the court means by notices. What we do know is that attached to the accelerated possession proceedings, there is a tick box form, and it may be that that's the notice. But other than that, I have not, at the time of writing these slides and as of this morning, seen what a notice is, seen any copy of a notice from the court service or anything to that effect. We also know that we are expecting more template documents and more notices to come out by the 18th of September, so by Friday. So keep your eye out for what those notices are. Again, with accelerated possession proceedings, which, remember, proceedings can be issued during the stay, but they are just automatically stayed. Accelerated possession proceedings must, when the claim is issued, the court must file with the claim, again, copies of these notices, which I think is a bit difficult if we haven't seen precisely what these notices are. But anyway, we hope that notices will be coming out by the 18th of September, so keep an eye out. You've probably all heard of priority listing. There will be a priority list, and that is again set out in the overall arrangements. It's probably no surprise that top of that priority list, one will see antisocial behaviour, but we also see rent arrears. Rent arrears are defined as 12 months rent or 9 months rent where that amounts to 25% of a private landlord's total annual income from any source. So a bit more information as to what type of rent arrear cases are going to be part of the priority listing. It goes on to squatters, illegal occupiers, allegations of domestic violence, allegations of fraud or deception, allegations of unlawful subletting, allegations of abandonment of the property and non-occupation, cases concerning what was allocated by the local authorities, temporary accommodation, and other circumstances that may warrant priority. It's also clear that subject to these priorities, further priority will be given to those cases issued before the stay in March 2020. Okay. Moving on, I talked earlier about the importance of notifying the court whether or not the pandemic had an impact on either the landlord or the tenant during the last 6 months. This is a key feature of the overall arrangements. I have to say, although it's a key feature of the overall arrangements, and you will see it mentioned in the overall arrangement document a number of times, and you will see what has been phrased COVID-19 marked cases, in practice, it is a little difficult to see precisely what impact it will have. And I say that because it may have an impact in terms of cases that are suitable for facilitated negotiation. It may have an impact on informing the court that a tenant has had particular difficulties as a result of COVID-19, and that explains the possession proceedings, and therefore it goes to issues of reasonableness. But other than that, I can't really see my reading of the overall arrangements what other impact it will have. And even as the law currently stands, any tenant attending a hearing that says my arrears are X because I've been unable to work, because I've been affected by a global pandemic, that would be a relevant consideration anyway. Having said that, it's not a bad thing that the court is aware, and it's not a bad thing that landlords are forced to provide this information. So what is a COVID-19 marked case? Well, the reactivation notice, as I've already said, requires a landlord and a tenant to provide COVID-related information. It's in the notice, as I indicated earlier, in respect of new claims. Any tenant at any time can request that the claim for possession is a COVID-19 marked case. Okay. It's not entirely clear how the tenant is to provide that information. Although there is a space within the reactivation notice for a tenant to provide that information, in reality, tenants are unlikely to be serving reactivation notices. Okay, it's not, in the main, it's not going to be coming from them. Okay, so it's unlikely that the court will receive it in that way. The current defence forms that I've seen, don't require information or don't prompt the tenant to provide information in respect of COVID-19 cases. And neither, I should say, does Practice Direction 55C. You won't see anywhere in Practice Direction 55C any requirement for a tenant to provide, or any opportunity for a tenant to provide COVID-19 related information. A tenant may be asked this specifically by a duty advisor at the review date, but again, to what end? There's no mechanism by which at the review date a duty advisor will be able to pass that information to the judge for reasons that I'll come on to in a moment. A tenant may be asked about COVID-related information at the substantive hearing, but again, that may be a bit late for reasons that, again, I'll explain in a moment. A tenant will be told in the notice that they will receive, and by the way, by the 18th of September, there'll be lots of notices that are going to be issued, and again, I'll come on to that in a moment. A tenant will be told in the notice that they receive, informing them about the reactivation notice, that they are able to make a short statement about their circumstances if they are unable to draft the defence. But again, it's not entirely clear if that's going to be a prompt to provide COVID-related information. So yes, on paper, it's it's nice and it's great that a tenant can at any time in the proceedings or in the process provide COVID related information. It's not entirely clear how that's going to happen. So what's the purpose of a COVID-19 case marking? The purpose is, as I said earlier, it highlights the suitability of settlement. Cases that are COVID-19 may be given priority in the facilitated negotiation opportunities, and I'll come on to that in a moment. Some social landlords have agreed to give special consideration to these cases. I've not seen that guidance. It would draw the claimant's mind to the defendant's difficulties, but again, if it's a Ground 8 case or a Section 21, I'm not entirely sure what difference that will make. It will assist the court in respect of listing, although looking at the priority cases, that doesn't seem to be a specified listing priority. And it will assist in monitoring, again, something I'll come on to in a moment. If a tenant or landlord, claimant or defendant does say that this should be a COVID-19 case marking, then they would have to provide some details of that. So it would not be sufficient to simply tick a box or to make a statement that this should be a COVID-19 marked case. They would have to provide some information as to what that is, and the overall arrangement set out what information should be provided, such as difficulties of hardship, furlough, shielding, ability to earn, whether the arrears arose before the pandemic or during the pandemic, and so on. That would apply to both the claimant and defendant. So the review date, we've spoken about the review date quite a bit. And I've said a couple of times now during this talk that it's not a hearing, it's essentially an appointment. It will be conducted by a judge on the document. So in practice, the way it will work, before I start going through the slides, just sort of you can picture it in your head, there will be a judge who is available should you need, okay? The review dates or appointments will be listed at the end of the day. And the idea is that a tenant and a landlord will receive notification from the court as to what the review date will be. They will not, or at least it's unlikely, that they will receive at the same time a separate substantive hearing date. So all they will receive is the review date here. The review date will be an opportunity for the tenant to make contact with a duty advisor to receive free legal advice at that stage. Okay. It is expected that the landlord is also available. The idea is that there will hopefully, possibly, be some discussion between the two. The idea is that they will hopefully be able to resolve something, whether it's directions or indeed the case itself. If there is any discussion between the two at that stage and they are able to either come up with directions or some sort of agreed order, they will be able to pass that to the judge who can then make the order. Okay? And that is why the judge will be available at the end of the day to allow the parties the opportunity during the day to have these discussions, and the judge at the end of the day will be available to make whatever order the parties are seeking, i.e. directions. Okay? It is not intended to resolve disputes. The parties will not be entitled to go before the judge, and it is not expected that possession orders will be made at the review date. Okay? Some of this is in the overall arrangement, some are not. The fact that possession orders will not be made at the review date is not within the overall arrangements, although that is what is understood. It is also an opportunity for the duty advisor to identify whether a case is suitable for facilitating negotiation, and again I'll come on to that in a moment. Okay. Now, there has been a lot of discussion in the working group and amongst those in it as to how this will work in practice. How will a tenant, for example, who receives a notice that they have a review date on a particular date, how will that tenant make contact with the duty advisor? How will that all be set up? The answer to that question is that it's court dependent and duty advisor dependent. And so don't be surprised again to see different practices arising in different courts across the country. HMCTS will publish, possibly by the 18th, I think by the 18th, will publish guidance for both claimants and defendants that will be given with the R date notification. That guidance will have, in big bright letters, possibly in red, whatever it may be, guidance to both landlords and tenants, what they must do in preparation for the review date, and the importance of taking early legal advice. Okay. There will also be different key point emphasis either in this guidance or attached in a different notice. Okay, so the idea is that both claimants and defendants have received an R date notification with a separate document setting out the key points, setting out the free legal advice that tenants are entitled to, setting out the importance of being available on the review date. Moving on. So in preparation for the review date, the claimant, by the landlord, will be required to provide an electronic bundle with a paper bundle as an alternative. The claimant will be required to confirm to the court that the paper bundle has been provided to the defendant with an electronic bundle where appropriate, if the defendant is able to receive that, and that the bundle includes the required material setting out all the enhanced information about the defendant, namely possibly all the COVID-related information. And to confirm to the court that the claimant will be available during the review date to discuss by telephone or otherwise matters with the duty advisor. Now, review dates will be listed, again, just trying to give you an example of how this will work in practice. The review dates will be listed on the same dates as the S hearing. Okay, so the duty advisor will be there on S hearings, on the substantive hearings, whilst also advising on the R dates. So the duty advisor will have to carefully set out their day so that they are available to give advice at the S hearing, which I'll come on to in a moment, whilst also being able to give advice on the R date. And you can see in the last bullet point I've put good luck, because many of us have been trying to figure out how this is going to work in practice, and I suspect that there may be some teething problems, and I suspect it's going to be a sort of learn as you go, and things may have to change if they're not working. Okay, but the idea is that the duty advisor will be given, if they're not given it by the tenant, will be given an electronic copy of the bundle, and hopefully that will be provided by the court. Okay. Now, if the case is not resolved by agreement between the parties, either because they've managed to resolve the claim itself or because they have agreed directions, the judge will consider the bundle that has been provided, the bundle that I've just spoken about, which hopefully will be in an electronic form, and will essentially undertake an almost tick box exercise to some extent. Okay. If the claimant's documents are in order, the case will proceed to an S hearing 28 days after the R date. If the claimant's documents are not in order, the court can be expected to dismiss the claim with liberty to apply for reconsideration at an oral hearing, or may give directions. Okay. So you'll see here what I was talking about earlier, and this is at paragraph 54 of the overall arrangements. The idea of the R date is not to resolve disputes. The idea of the R date is for the judge to simply make the order that the parties have themselves managed to resolve. What is important from this is that the judge may dismiss the claim. Now, we don't see this in the practice direction. It's not in practice direction 55C, and we don't see this in any other changes to the CPR. So this is essentially a case management power that the court has under CPR Part 3, which is why I said earlier on that CPR Part 3 is doing a lot of the heavy lifting. Okay. The next point, and again, I think I said this earlier, that no possession orders will be made. But again, query those possession orders that are possibly made by consent. Okay, the overall arrangements are silent on this issue, and so is the practice direction. Importantly, local authorities will be expected to take the approach that signing a consent order at this stage or agreeing an order for possession itself does not mean that a tenant or borrower should be found intentionally homeless. Now, again, you may say there's perhaps no difference in the law as we currently understand it. But there will be guidance issued by the Ministry of Housing, so watch out for that. But I think it is important that this has been specifically highlighted in the overall arrangements. The purpose and the point of the overall arrangements is to facilitate compromise and negotiation, okay, to take the pressure off the courts and to ensure, I hope, that fewer possession orders are made that results in people being found homeless. That is what really underlines the overall arrangements. So although there's no substantive change in the primary legislation as currently applied, the fact that this is highlighted in the overall arrangements, I think, is important, and watch and keep an eye out for the guidance that's expected from the Ministry of Housing. Now, again, the review date, sorry, I'm looking at time, gosh, okay, I'll be as quick as I can because there's still quite a lot to cover, but the review date, the idea is that at the review date, people will be signed up on certificates so that work can be undertaken between the review date and the substantive hearing, okay? There's going to be people that will not be signed up to certificates at the review date for obvious reasons, but they will still have duty advice at the substantive hearing. So I'm going to try and speed along. There's two main points that I want to raise. The facilitated negotiator is an entirely new concept, never really been seen in the housing world in this way, although of course mediation has always been available in housing cases should the parties want to use it, as in any case. This is now very much part of the overall arrangements. I should say this, it's not coming in until the 20th of October. There will be a steering group, those on it have yet to be finalised, but there will be a steering group to look at precisely how this is going to work in practice. It's not compulsory, it's not means tested, but at the review date, the duty advisor will have the task of deciding whether or not, in their professional opinion, the case is suitable for facilitated negotiation. Okay? If it is, it will then go to a negotiator, facilitated negotiator, sometimes referred to as the mediator. These terms are used interchangeably in the overall arrangements, and there has been a lot of discussion about whether it should be called a mediation or not. Everything that happens during the course of the facilitated negotiation remains confidential. I think the aim is that there will be, between now and the end of the pilot scheme, which is March next year, around 7,000 cases that will hopefully be referred to as suitable for being negotiated. I understand that it's hoped that duty advisors will refer at least 2 cases whilst they're on any given day. There will be no fees payable at any stage, and the facilitating negotiations will have some training. Okay, so again, the details of how the facilitating negotiation will work are still to be ironed out. That will be the job of the steering group, which is yet to be finalised. But this is certainly a new approach, and again goes to the very purpose of what's in the overall arrangements, which is to encourage settlement. So substantive hearings, I'll cover substantive hearings and I'll end. Thanks, Tim, for the notice. I'll be as quick as I can. Substantive hearings are, I suppose, if one keeps in their mind essentially what we currently have as the first hearings, Rule 55.8 has not changed. The court will still have to consider Rule 55.8 as any substantive hearing. They will be listed 28 days after the review hearing if the case is not settled or further directions have been given in the interim. They will, the primary position is that they will be face-to-face unless certain exceptions apply. And unless the parties agree that the hearing should be by way of video or phone link. Remember, they're going to be at 15-minute intervals to allow for safety precautions in between. I should say that the government rules on distancing are changing, and they're likely to change by the end of the year, so this will be kept under review. The judges, again, we're told that judges have been recruited. A further 200 deputy district judges have been recruited to hear these cases. We are told that they are to be given some training, and I understand that that has indeed already happened. Just to point out, when you do have a chance to look at the overall arrangements, take note of paragraph 63 of the overall arrangements and Rule 55.8 of the CPR. What you will see in the overall arrangements is the idea that where there are complex issues, the case should be adjourned for directions. That phrase, complex issues, or the requirement for evidence does not appear in the civil procedure rules themselves. But what is interesting in the overall arrangements at paragraph 64 is that the court will consider an adjournment without the need for an application to adjourn in any case where there is no sign that advice has yet been made to the defendant, has yet been given to the defendant, and secondly, where the consequences of the order may be serious in the context of the pandemic. Again, we see the theme that underlies the overall arrangements, the theme being that it's encouraging early legal advice, it's encouraging settlement, and it's taking note of those individuals that have been affected by the pandemic. Moving on very quickly, I won't cover accelerated possession proceedings, save as to say that, again, for the first time, we see in the overall arrangements that accelerated possession proceedings can, where the parties agree and there is no objection, be referred to a review date. The reason that this is happening is because if a case is referred to the review date, it allows the duty advisor to consider whether or not the case is suitable to be referred for facilitated negotiation. Again, underpinning the very essence of the overall arrangements, which is to encourage settlement. Lots of guidance still to come. I've set that out there, so I won't go again into any detail, but I'll let you read that for yourselves. And lastly, sorry, Tim, I know I've gone way over, but lastly, the warrants stage. Again, we're all familiar with the changes in respect of warrants. You're going to have to give 14 days notice. The only point I would make there is that now that tenants are getting notice of warrants that have been applied for in the High Court, no doubt more tenants are will possibly be making applications to suspend those warrants, and I query whether or not tenants in the High Court should also be getting duty advice in the way they currently do not. I'm sorry to have rushed through it at such speed. There's a huge amount to get through. I will try and answer questions as best I can at the end. If Simon Mullins is here also, Simon, do feel free to answer any questions along me at the end when I'm answering them. Okay, thank you very much. Liz, over to you.
Marina, wow, thank you. Just to confirm to colleagues that you are going to get all these slides and you'll be able to pore over the detail with a fine-tooth comb, which of course we will all need to do. I have to say, as I was poring over the detail of notice periods, which I'm going to deal with now, I thought I'd drawn the short straw because my head was spinning. But once I read Marina's slides, I realised that I'd come out of this really easily and that actually notice periods are much, much easier than the complex new procedural rules that we're all going to have to grapple with. Just a word on some of the more political legal points, and in particular the abolition of Section 21. The government fought the general election in December, committed to the abolition of Section 21, long before coronavirus, nothing to do with coronavirus. That was in their manifesto and it was in their Queen's speech. Having been elected in December, they promised to bring in a Renters Reform Act. Obviously, they didn't know there was going to be coronavirus and they didn't know about the moratorium, but you would have thought that what has now become a 6-month moratorium on possession claims would have given the government the opportunity, once Parliament started sitting again in about May or June, to bring forward their existing commitment on the abolition of Section 21 and legislate for that in time for it to be in place by the time that court started again. They have not done so. They were asked by the House of Commons Select Committee in May, a select committee that obviously comprised both Tory and Labour MPs, which recommended the short-term suspension of both Section 21 and Ground 8. And they were asked about their plans to abolish Section 21, and the government's answer was that this is the most complex piece of housing law reform for 30 years, and therefore they need to get it right. But we still have no plans, we have no timetable, we have no published abolition of Section 21, which is a considerable disappointment. Where are we with notice periods? And first of all, where were we? Well, looking back at the history, it's not that long ago, because I'm not going to go through the various notice periods that existed for different notices up to March. But on the in the Coronavirus Act 2020, Schedule 29, which came into force on the 26th of March, I think the day after Royal Assent, amended notice periods. And very broadly, it provided for 3-month notices for Section 21 notices, notices to secure tenants, notices to assured tenants, notices to flexible, introductory or demoted tenants, and notices to rent out tenancies. So we had three-month notice periods from the 26th of March. So if we can move on, Marina, I'm sorry, I should have said Marina is in charge of the screen, and therefore she's in charge of everybody, and it means that I have to ask her to change the slides. So we were living with 3-month notice periods. Landlords during the moratorium could serve notices, providing that they were in the right form and giving the right notice period, and even could issue possession claims. But of course, as soon as those claims are issued, then they were automatically stayed because of the moratorium. So we are likely to see landlords who had their act together during the moratorium and who want to evict their tenants applying to reactivate claims that were issued from the 26th of March, but obviously were stayed. How do you find out about the new notice periods? Normally when I do this sort of training, I say, go to the regulations. It's all clear if you go to the regulations. You could go to the regulations, but I'm warning against it because your head would spin. The regulations, which are the Coronavirus Act 2020, brackets residential tenancies, protection eviction, close brackets, amendment, brackets England regulations 2020/914, which were published on the 28th of August and came into force again the following day, the 29th of August, themselves amend Schedule 29 of the Coronavirus Act 2020. You think that's not so bad? I can have the regulations in front of me. I can have the schedule in front of me. I can just start kind of annotating one of them. And then you go to the schedule and you realise that it in itself amends all the primary legislation, notably the Housing Act 1985 for secure tenants and the Housing Act 1988 for assured tenants, including assured short-hold tenants. And that's when your head starts to spin. So the foolproof way of checking the primary sources is when the various legal websites have updated their amendments to the primary statutes, to the Housing Act 1988, 1985, and so forth. Certainly as of yesterday, Westlaw, which Garden Court subscribes to, had not done so. I doubt very much whether the government legislation website has done so because that's always slow. So what I would say, besides, of course, these slides, which you're all going to take home and treasure, there is a very, very helpful guide on Giles Peaker's Nearly Legal blog, and he has also updated his Section 21 flowchart with notice periods, and Shelter's housing advice website is up to date and contains the new notices. So that's what the regulations do, and that's where you're going to find them. The regulations apply to England only. Obviously, Scotland is another country for legal purposes. Wales is also another country for housing law purposes, and they introduced their own extended notice period from July. Again, Giles Peaker on Nearly Legal has a guest post from Mike Norman in Wales explaining what the Wales regulations are doing. I'm not going to talk about Wales any more than that. So, Marina, next slide, if you would. Thank you. Right, Section 21 notices. This is relatively easy. All Section 21 notice served on or after the 29th of August have to provide for a minimum of 6 months notice period. You will know that until the 29th of August, landlords had 6 months from service of a Section 21 notice in which to issue a claim for possession. Clearly that is not workable, so that period has been extended to 10 months. So any notices that you see served from the 29th of August must be 6 months. If they're 2 months, they're no good. If they're 3 months, they're no good. I saw there's a question from Felicia about what happens in respect of notices served before the 29th of August, and I am going to come on to that. Okay, so actually Section 21 notices, it's easy. If it's the 29th of August onwards, it's 6 months. Next slide, if you would, please, Marina. What about assured tenancies, which are obviously include assured short-hold tenancies if a private landlord has chosen not to use the Section 21 procedure, and otherwise will include most tenancies granted by what I still call housing associations. And that's a little more complicated. And what this does is it reflects what the government said its aim was, that 6 months notice period should be the norm, except for more serious cases. So the starting point is the first bullet point is for the lesser used grounds of possession. And I confess, I've been a housing law specialist for more years than I care to remember, but I still had to look up what the different grounds were. I've given you them. Most of the lesser grounds require six month notice period. For rent arrears, ground 8, ground 10 and ground 11, then if the arrears are less than 6 months at the date of service of notice, then it has to be 6 months notice. So that reflects two policy aims, it seems to me. One is the policy aim that is also contained in the new procedure, which is that the government wants to ameliorate the prospect of evictions where people have accrued rent arrears as a result of the economic consequences of the last 6 months. And the second is that they do want to give the opportunity to courts to prioritise those who are in more serious breach. So they put that as 6 months arrears or more. So if the arrears are less than 6 months at the date of service of the notice, then you get 6 months. You get a 3 month notice period for ground 7, which is where someone's, anyway, it's self-explanatory, and for ground 7B, which is where the landlord's been told by the Home Office that the tenant or one of the occupiers has no right to rent. And Marina, if we can have the next slide. And then a 4-week notice period for rent arrears if the arrears are 6 months or more at the date of service of the notice. A 2-week notice period for 2 of the antisocial behaviour grounds, 14A, the one relating to domestic violence, 14Z, the one relating to conviction for riot, or where a tenancy is induced by false statement. You will note that what is not on that slide is the normal antisocial behaviour ground, which is ground 14, and the only interpretation of that is that ground 14, therefore, although it requires a notice, unless the notice is dispensed with under the Housing Act 1988, does not require a notice period. A notice can be served and possession proceedings can be immediately, in practice the next day, issued. So ground 14, no notice. If a notice contains multiple grounds for possession, then the period is the longest notice period that is relevant to one of those grounds. So that's assured tenancies. What about secure tenancies, Marina? Secure tenancies, practically identical to assured tenancies. 6 months notice for rent arrears if the rent arrears are less than 6 months at the date of service of the notice. 6 months notice for pretty much everything else, all the other grounds for possession, except 4 weeks notice if it's 6 months rent arrears or more. 4 weeks notice for, again, 2 of the antisocial behaviour grounds, ground 2ZA, conviction of indictable offence, ground 2A relating to domestic violence, and again ground 5, a false statement inducing the grant of a tenancy. Again, you will ask, well, what about ground 2, which is the normal antisocial behaviour ground, or indeed the absolute ground for possession at section 84A? The same point. No notice period is specified, and therefore a notice must be served, but no need for any period. In a reverse from the position for assured tenancies, if you have multiple grounds for possession in the notice, then you go with then the notice period is the lower of those multiple grounds for possession. So if any of the 4 week ground is specified, then it's 4 weeks. Otherwise, it's 6 weeks. Next one, if you would. Rent out tenancies. Obviously, we don't see those very often. There aren't many of those around, but essentially the same thing. If there are 6 months or less rent arrears, then it's 6 months notice. You will note, and Giles Peaker spotted this on Nearly Legal, so I credit him with the point, that the wording for rent arrears is slightly different. It's 6 months or less arrears to get your 6 months notice. In other words, if at the date of service of the notice you have exactly 6 months arrears to the penny, then under the Rent Act you get the longer notice period, 6 months notice, but under the 88 Act and the 85 Act, so for assured tenants and secured tenants, if it's 6 months notice, it's a shorter period, it's considered serious, so there's 1 day out. 3 months notice where there's no right to rent, and then again, if it's more than 6 months rent, then it's 4 weeks notice. And the same point, if there are multiple cases specified, then it's only the lower period of those various cases that need to be provided. And the next one. And then it all gets a bit easier with the 3 different sorts of tenancies where broadly the social landlord just has to serve a notice and can then, subject to an internal review, can then bring possession proceedings which will be on mandatory grounds in the court. Broadly, 6 months notice is required for flexible tenancies, introductory tenancies and demoted tenancies, unless the reason why a landlord is choosing not to renew an introductory tenancy or a demoted tenancy and to seek possession is an ASB reason, and ASB refers directly to the definition of ASB in the Housing Act 1985. And onward. And we have new prescribed forms. The most important one is the new prescribed form 6A for section 21. You will know that section 21 provides that if the landlord doesn't use the prescribed form 6A, then they cannot rely on the section 21 notice. They can't just make up their own section 21 notice. I've given you the link there. And next one. So for section 21 notices, obviously the same analysis here applies to any other notices, but the important thing is section 21 notices, and once you've got your head around that, the rest of them fall into place quite quickly. Would you still be in a position where you would be helping a tenant defend a section 21 notice that had 2 months notice to it? Yes, you would, in 2 positions. One is, of course, if there was an existing possession claim that had been issued relying on section 21 before the 26th of March. So it had been issued, it had not been determined, and it had been stayed. It will be reactivated, and you're into the territory that Marina described. You could also be in a position where a 2-month notice was served up to and including the 25th of March this year. The landlord had 6 months in which to issue the claim. The moratorium did not prevent the landlord issuing the claim, although it prevented, of course, once issued, any steps to be taken. And so you may have had a 2-month notice that was served on, say the 1st of February, and the landlord issued proceedings on the 1st of April, and they have been stayed. So you may still be seeing 2-month notices. If any notice served between the 26th of March and the 28th of August had to be 3 months notice. Again, the claim for possession had to be issued within 6 months of service. Supposing you got a landlord who was very on the ball and served a 3-month notice on the 26th of March of this year, then they would have been able to issue possession proceedings on March, April, May, June, unless I'm out by a month. But the 27th of June this year, again, they would have issued and it would have been stayed. And it may well be that you have a 3-month notice that was served on, say, the 27th of August. So a landlord has 6 months from the 27th of August to issue the claim for possession, relying on their 3-month notice. So the tenants who have now got most protection are those where the landlord has served a notice on or after the 29th of August, and under section 21 that will be a 6-month notice, and it will also be 6 months if the arrears for other tenants are 6 months or less. Are 6 months or are less than 6 months. It's important to get that distinction. So Marina, so this is really the same point. Who could be in front of the courts? Of course, anybody who was already subject to a claim before the 26th of March, any claims that were issued but stayed after the 26th of March, claims that are issued relying on notices served during the moratorium, and in any event then licensees are not protected under these new regulations. They will be entitled either to a 4-week notice to quit or to reasonable notice, and squatters, unauthorised occupiers and so forth were always before the courts and were not subject to the moratorium. And the next one, there is government guidance. It is guidance. It's regularly updated. They started issuing this in March. It's regularly updated. That's the most up-to-date link. They are strongly advising landlords not to serve new notices seeking possession during this challenging time, and there is useful guidance on the points that we've been making and the government's view on them in those different paragraphs. And then I think finally, what's to come? Well, what's to come is the announcement just 6 days ago. Government sets out comprehensive support for renters this winter. So we have no regulations, we have no legal materials backing up this announcement, but we are told that eviction will not be enforced in local lockdown areas, that there will be a winter truce on enforcement in England and Wales in the run-up to and over Christmas. You asked me what the run-up to and over Christmas is. I don't know. The government is going to tell us at some point, except in the most serious circumstances, such as cases involving antisocial behaviour or domestic abuse, and guidance will be issued to bailiffs, more or less saying the same thing. And there is more money. The government, to some extent, I don't want to talk them up too much because not in my nature, but they are throwing some money at local authorities in order to help with this. There is more money for discretionary housing payments. I put on Twitter when the notice period came out that we were beginning to win, and there was some discussion amongst housing lawyers who are on Twitter, and clearly we haven't won because the obvious thing was abolishing Section 21. And like I say, the government, although committed to do it, isn't going to tell us when. But what is clear is that where we had a position back in March that we had a moratorium to June and we had 3 months notice periods, we are now in very different circumstances, and we are in circumstances where a lot of tenants who have incurred rent arrears as a result of the difficulty with coronavirus are going to at least get that extended notice period, which either allows them to get back on their feet or to find somewhere else or what have you. There were predictions of a tsunami of possession claims reaching the courts in August, which is why the government did its second extension of the moratorium to September. There isn't yet going to be the tsunami. It's going to be a trickle up to Christmas, maybe a slightly more active brook running between Christmas and March, but it may well be that we have a tsunami of possession cases from March next year onwards. Tim, I'm very happy to answer any questions. I saw that some were coming up in the chat. Are you able to select them for us?
Yes, I am. I'm not going to be able to ask all the questions, but what I'll do is I'll try and start with ones for Marina. And I'll start with the very first question that was asked. And this was asked by Olivia. And it's where the parties have agreed and complied with directions pursuant to Practice Direction 51 ZA 1A, will one of the parties still need to file a reactivation notice, assuming everyone's trial ready?
Yes. Any cases before the 3rd of August require reactivation notice, and if you're trial ready, you would notify the court of that when you serve your reactivation notice.
And a linked question is from Lucy. And it says, do you think reactivation notices will be required where you've made an application to set aside a possession order?
Well, that's an interesting question, because Practice Direction 55C talks about reactivation notices not being required for final orders. All right, so no one quite knows what a final order means because it's not defined in the Practice Direction, and I'm afraid it's not explained any further in the overall arrangements either. So one could arguably say that a final order is an order that is not being appealed and is not subject to any applications. It's a circular argument. It's not being appealed and it's not subject to any application to set it aside. But if it is being appealed and if it is subject to an application to set it aside, then maybe question mark, is it not a final order? And if it's not a final order, then the requirements of Practice Direction 55C applying a reactivation notice must be served. So it's a circular argument. I'm afraid there isn't a very clear answer to it. It all depends by what is meant by a final order.
This is from Sophie, and there are some linked questions again in respect of the review date, and I think this is aimed to Marina. And from Sophie, it says, what incentive is there for landlords to ensure they are available on the review date? If no sanctions, I can't see private landlords bothering on the whole, especially using section 21.
There is a, sorry, yeah.
And also, there's a related question from Lee about, is it expected that parties attend court in person on the R date?
No, so just in terms of the first question, are there any sanctions? The only sanction that is mentioned throughout the entire overall arrangements is the sanction that the court can dismiss the claim at the review date if the landlord has not complied with the relevant requirements. That's the only sanction. That is not reflected in CPR 55C. It is expected that that is simply a power that the court can use under its general case management powers, CPR 3. So the incentive to the landlord is to make sure that not only, because they have to confirm to the court that they are available at the review date. Okay, that's part of the requirements. They have to notify the court that they will be available at that date. So when the judge at the review date is going through the tick box exercise and sees that something along the way hasn't been properly completed or landlord is not available at the review date, the judge does have the power, and I say it's the only sanction that we can see, to dismiss the claim at that stage, or alternatively, make further directions. Sorry, Tim, can you remind me of the second question?
I think it was, is it expected that parties will attend the court in person on the R date? No,
so the R date can be done by telephone. I think, again, that's going to be court specific. One of the issues was to ensure, one of the issues that the working group were looking at is how do we ensure that all parts of the country are covered to avoid housing deserts, because the very essence of the overall arrangements is that people obtain early legal advice, and that's undermined if that early legal advice is not available in some courts. And so it can be done remotely. I think it's likely to be done by telephone advice. It's likely that a tenant will have to, there'll be some way for the tenant to communicate with the duty advisor. It's likely to be by telephone. Who is going to be responsible for managing that? It's not quite clear, all right? But I think the way it's going to work in practice is that when the tenant receives the R date notification, on that R date notification, there will be details as to how that tenant is to make contact with the duty advisor. And it's probably going to be something along the lines of, your R date is on this date. Please contact the duty advisor between this time and that time. Or you will be contacted by the duty advisor and please be available between this time and this time. So it'll be something along those lines. It'll be dependent on the system established between the court and the duty advisor.
Marina,
just another point on that. No. To encourage landlords to take part in the R date, it is not intended that the S date will be listed any time before the R date. So for a landlord to get the S date, where the possession order that he or she seeks may or may not be made, to get to that stage, they have to really partake in the R date, because it's only at the R date that that S hearing will be listed. We think that's the intention of the overall arrangement.
Maureen, I'm just going to ask you one more question, and it comes from Julia. And there are two bits of the question, because Julia's asked two questions, but I think that it's useful for you to answer them both. And the question is about what do you mean possession orders won't be made at the R date? She asked again, what orders will they make? And presumably if the parties agree an SPO, then that will be made, or if a defendant agrees an outright order, that will be made. So that's just the first question about, can those orders be made at the R date? And the other question is about the application of these procedures to mortgage possession proceedings. Do they apply to mortgage possession proceedings?
Okay. Thanks, Julie, for those questions. I feel like I'm on question time, and I'm sort of taking a note of the questions. Julia, your point about possession orders, what do I mean by that? Okay. So the Practice Direction 55C is silent about possession orders at R date. The overall arrangements are silent about possession orders R date. All of the discussions that the working group have had is on the basis that the court, the judge, will not be making possession orders at the R date. Now, you question what about possession orders that are reached by agreement? Well, that's a good point, and there's been lots of discussions about that also. Arguably, parties can at any time send a court order into court made by consent, for example, in a Section 21 notice case, and ask the court to make the order. The difficulty comes with those claims that are brought on discretionary grounds, because what you are asking the court to do when making an order brought on discretionary grounds is to enter into some judicial consideration, some fact-finding as to whether or not, firstly, the grounds are made out, and secondly, it's reasonable to make that order. That is not the function of the court at the R date. The parties are not able to go before the judge at the R date. All communication with the judge at the R date will be done via the usher. There will be ushers who are allocated to a specific judge in respect of possession proceedings. So my understanding of the overall arrangements and of the practice direction is that, particularly when it comes to possession orders, possession claims for discretionary grounds, the judge will not be allowed or should be discouraged, and it will not be the practice that is encouraged, certainly in the judicial training, to be making possession orders at the R date. In respect of possession proceedings, if you look at in my slides, I deal with the guidance that is due to come out in respect of possession proceedings. Claims are to be postponed. Claims by mortgage lenders, in respect of mortgage cases, are subject to regulatory and voluntary schemes under which, with appropriate exceptions for priority cases, claims are postponed to 30th of October. The only exceptions in respect of how the practice direction applies are those that are set out in the practice direction, and those are the claims that are brought after the 3rd of August, and those claims that where a final possession order has been made. Is that it, Tim?
Yes, that's the inquisition of you, Marina. We now it seems that Angus at the end says that the general view is that duty advisors is we should not agree any orders at the R date other than an adjournment.
Yeah. Oh yes. Good point, Angus. Yeah.
So I think Angus is he rose up out of his duty chair and announced what he wanted to do, what he thought was the best practice. There's a question.
Sorry, Tim, can I just add on that point? Our dates will be listed for 5 minutes at the end of the court date. Okay, so the idea that judges are going, it's just not practical. Judges are not going to be making possession orders at our dates, in summary. And Angus is absolutely right. Duty advisors will not be agreeing to them.
This is a question from Andy. He's asked 2 questions, and I'll try and combine them. And it's related to notices. So we're getting into Liz's territory. And it says, And he asked, can you cover the circumstances where the wrong notice has been used by the landlord? And he puts wrong in inverted commas, e.g. 2 months Section 8 after 26th of March, but legislation allows the notice to be read as 3 months. And Andy says, I think there's some difference between Section 21 and Section 83 here. And he also asked a little later on, from the 26th of March, Protection of Eviction Act was modified to require 3 months notice. This has now disappeared. I think Liz asked that, answered that question in her talk, but just to clarify those points, I think.
Okay, so let me deal with the Protection from Eviction Act first of all. The Schedule 29 of the Coronavirus Act did, and Andy, you're absolutely right, they use this interesting phrase, is to be read, rather than modify or amend the Protection from Eviction Act, which is what makes that even more complicated, because I've just, in order to answer your question, I just had a quick look at Section 5, Protection from Eviction Act, on Westlaw, and it's not been amended. And the reason for that is because the Coronavirus Act doesn't amend the Act. It says Section 5 of the Protection from Eviction Act is to be read. So that makes your head spin in the first place. But what the Schedule 29 did is it said that Section 5 of the Protection from Eviction Act is to be read in relation to Rent Act notices to quit given by the landlord during the relevant period, as if the reference to 4 weeks were a reference to 3 months. So the March legislation in the Coronavirus Act did not extend the notice period for licensees. It simply extended notices to quit notice period for Rent Act tenants. And therefore, so no change in March, and the new regulations for notice periods do not, insofar as they amend or say to be read Section 5 of the Protection from Eviction Act, they do it solely in relation to Rent Act 1977 protected tenants, and you've got a slide on that. So that's the first point. Now, the second point, the circumstances where the wrong notice has been used by the landlord, but the legislation allows the notice to be read as 3 months. So you've picked up the statute. Absolutely, that's quotation. I think there is some difference between Section 8, Section 21, Section 83 here. Andy, you have the march on me. I would have to do a bit of thinking about the differences between Section 8, Section 21, Section 83. But I think the starting point is that if a wrong notice has been used, so landlord serves a 2-month notice after the 26th of March, and then say in July has issued possession proceedings relying on that Section 21 notice, then you would, the tenant would be defending, once the claim has been reactivated, the tenant would be defending the claim for possession on the basis that the wrong notice has been used. And that gets us into all the existing law about the extent to which a notice is the same or substantially the same as the requirements with the legislation. And you're right, the law about Section 21 is materially tougher on what is prescribed and what is necessary than those for Section 8 and Section 83. Where I think I think you need to be careful about is, as I say, you sent me scurrying back to the legislation. I was so pleased that Marina had those questions first. And I looked again at the phrase in the Coronavirus Act, Schedule 29, where it says, where it uses to be read as. And that to me, and I'm very happy to have a discussion with you outside of this, these circles, is that to me is a reference to how the legislation is to be read rather than how the notice is to be read. And so I see the point you're making. You're saying, well, if it's wrong, can it still be read as a correct notice? But actually my view is if a notice is wrong, you're into all the usual defences that a notice was wrong, it used the wrong notice period that was prescribed at that time, and the tenant just has to be quite firm about on the basis of the defence. So feel free to email me if you disagree with my interpretation of the legislation. It's not, as I say, it wasn't until you asked the question that I started thinking about it, but it seems to me that the legislation is referring to the primary housing legislation when it says that it should be read that way, not to the notice.
I think we've got time for just two more questions. The first one is it's from Emma Collins, and it says, is a person served with a new 6 month section 21 notice still threatened with homelessness for the purpose of homelessness applications?
And that's me, I take it. Emma, I'm very glad you asked me that question, she says, sounding like a politician. And the reason I disappeared just now is because my copy of Part 7 of the Housing Act 1996 is on the floor by my desk, which is where it lives. And I was thinking about this last week when I was advising on a homelessness case. The short answer is that no one's grappled with it. The guidance doesn't deal with it. The code has not been updated. There's nothing sent out to local authorities in relation to homelessness. The government hasn't said anything, and nobody has thought about it. So in the absence of any guidance, we just have to look at the statute ourselves and try and work it out. The difficulty is that section 175 subsection 5 of the Housing Act 1996, which is a bit that prescribes that if in normal circumstances, pre-coronavirus, somebody was given a valid section 21 notice, then they would be threatened with homelessness and therefore entitled to the prevention duty. It actually says this: a person is also threatened with homelessness if a valid notice has been given under section 21, that's fine, and that notice will expire within 56 days. So of course that's not the case in the first 4 months of a 6 month notice. So I think the short answer is we're going to have to try and find out. We will see if people go along to Homeless Persons Unit with their 6 month notice, and what the Homeless Persons Unit then says. The worst case scenario would be you come back 4 months into the period of the notice, because then you're clearly within section 175 subsection 5. But there's no guidance, nobody knows. That's what the statute says. No doubt lawyers will argue it out at some point.
There are a number of questions on notices which may or may not have been answered within the seminar, but if Liz and Marina are happy to address the remaining ones by email, that would be great. The final question I'm going to ask is related to warrants, and it's from Lucy, and it says, is there any guidance about what is to happen with existing applications to suspend warrants? Are they going to be relisted or subject to some kind of review? I think that's probably Marina.
Yeah, interesting one. Again, practice direction probably doesn't apply because it's final orders. I don't know of any further guidance. I don't know of any guidance. It's not expressly dealt with in the overall arrangements, other than to simply say that duty advisors, when they are sort of juggling R dates and S hearings, will also at the same time be dealing with applications to suspend. That's all I can say at the moment on that from the information that I have.
I think we're just about out of time. Thank you all very much for your questions, and I'm sorry that if we haven't answered absolutely every question that people put into the chat room, and we'll try and identify those that we haven't answered and try and address directly if possible. And thank you very much for attending today. At quite short notice, there's been at its height 197 people attending this webinar. I think it was only, I think we've only had one that is slightly more people than that.
I counted 200, Tim. I counted 200.
When I looked, it was 197. But even so, I think the maximum has been 288 in a previous one. But thank you very much for everyone for attending, and I hope that you found it very helpful and useful, given that we're in a situation where the stay lifts the beginning of next week. There may be a little bit of breathing space for the courts of about 2 weeks before it starts to wind up again, and maybe we'll have about another month to get our minds together and our heads around these complicated changes. I doubt very much that this will be the last word, and as I understand from Marina, that the Working Party is still meeting, so things may even change during the periods of change. Hopefully we're coming out of the pandemic and we won't get a massive second peak, but we can't tell. And I think in the end we have to see how each individual courts react and how they process possession matters from now on. And I think it will be a learning curve, a sharp one for everyone in different areas. So thank you very much for attending. As we said, we'll be sending you the recording of this and copies of the slides and everything. And if there are any follow-up questions or anything that you feel you want to raise in respect of the webinar, please let us know. Thank you very much, and thanks for all attending.